Welcome to the Massachusetts School of Law Educational Forum. Our topic today is one of special importance to the ordinary citizens of the United States. It is misconduct by federal and state judges who sit in judgment over us. For scores of years, we as citizens have been taught the civics lesson that judges are accomplished and distinguished individuals, are fair-minded and objective persons who make their decisions on the basis of facts rather than prejudice, and in general, are persons who are worthy of their place atop the ladder of prestige in this country. Those of us who are lawyers were taught the same thing in the law schools, and the lawyers who began to think differently after being in practice rarely said anything publicly about their views, because doing so would breach the profession's etiquette and be disastrous to their careers. There are many judges who live up to the civics model of what a judge should be. On occasion, I have been lucky enough to know some of them personally, such as the marvelous gentlemen who teach at our law school. But in recent decades, there has been more and more information coming out which shows that, far too often, far too many judges fail grossly to live up to what we expect of judges. As detailed in a recent issue of an MSL intellectual magazine called The Long-Term View, there are now extensive complaints about the following types of conduct, among others, and about the failure to cure the problem. There have been some judges who were plain dishonest. They were on the take. Too many judges are arrogant. They treat people in their courtroom like dirt. There has been gross bias against women and mistreatment of them. There are judges who make decisions on the basis of their prejudices. They ignore the facts, and when necessary to reach a decision they desire, they make up the facts. There are judges whose views are one-sidedly pro-establishment. There are judges who let representatives of the powerful break procedural rules at will, while not allowing the poor or the non-influential to obtain the benefits even of procedural rules they have a right to use. Judicial councils and commissions set up to investigate complaints about judges protect them instead, because the commissions are overwhelmingly comprised of judges and lawyers. The media generally is uninterested in and fails to cover the problem, and there are very few court-watching bodies comprised of citizens who regularly sit in courtrooms to observe and report on what is going on. These and associated problems are so important and so disturbing that, as I said, MSL recently devoted an entire issue of a magazine to them, and today we have assembled a group of extremely knowledgeable people to discuss the problems on this program. With me today are, on my right, Jan Schlichtmann. Jan is the lawyer who brought, and in the face of judicial antagonism for many years pursued, the now famous Woburn, Massachusetts case involving the chemical poisoning of groundwaters. The case is the subject of the recent best-selling book called A Civil Action, which is being made into a movie. On my immediate right, Sydelle Pittas. Sydelle is a highly experienced litigator in the Boston area, and from her office in Winchester, currently specializes in intellectual property issues and business disputes. She is a member of the Board of Directors of the Women's Bar Association and formerly was on the Board of Trustees of the Women's Bar Foundation. On my immediate left, David Greer. David is a highly experienced practitioner in Boston, is a marvelous teacher at MSL as well as at undergraduate schools, and is a member of a committee which passes on applicants for state judgeships in Massachusetts called the Judicial Nominating Committee. And on my far left, Martin Oberman. Marty, a practicing lawyer in Chicago, is head of the Chicago Council of Lawyers, a prominent legal group in that city. The Chicago Council, unlike any other bar group I know of, has published extensive reports on the professional characteristics and qualities of federal judges in its area. And I am Lawrence R. Velvel, the Dean of the Massachusetts School of Law. In the interest of disclosure, let me say that, although I am the moderator here, I have deeply felt views on the subjects of today's discussion because, as a practicing lawyer, I have been involved in cases where the problems existed to a fare thee well. Ladies and gentlemen, let me open, I hope it's proper to say lady and gentlemen, let me open by asking, perhaps Marty can handle this, to outline for the audience what should be obvious, is certainly obvious to us as lawyers and should be obvious to the citizens of this country. Why do we have a right to expect the highest standards of conduct from federal and state judges? What is your opinion on that?
Well, I think we start by examining why we have a court system in the first place. And it really is simple, I think, and basic. In my view, since people first came out of caves and decided to come together in communities, we needed a mechanism to resolve disputes. In the United States, the court system, I think, serves two functions. One, it is a place to go and have disputes resolved. Two, and equally important, perhaps more important to our democracy, the court system has been a place that is a constraint on the other branches of government. and both of those points are fundamental to the operation of a democracy. If people do not have confidence in having their disputes resolved in a court system, what's the alternative? They're going to take a gun and walk out in the street and solve the problems themselves, which unfortunately, of course, still happens. So it's absolutely essential for the functioning of a free society that people, when they have a dispute, can take it to court and have the belief that they will get a fair and impartial hearing. And so all of the problems that you outlined, and many I assume we're going to talk about, undermine the public's confidence and willingness to trust in the court system.
Right. David, as a practicing lawyer, the people you have represented so often have had involved, have they not, the most critical questions concerning their lives and property when they go to courts to have either forcibly or voluntarily to have disputes resolved?
I find that once we're in court and there is a disposition by the court, the client would normally turn to me and they would say that why is it that my property has been taken away from me? Why is it that my child is, I can't see my child? Why is it that under the circumstances that I have no visitation rights? In the probate setting, you find that judges are given so much leeway and that they make decisions every day what is in the best interest of children, what is, of course, is in the best interest of families. And we just finished talking about the fact that the Supreme Court, as of yesterday, for the Commonwealth of Massachusetts, stated that now judges will now be able to make decisions in regards to which church a child should go to. So,
David, let me say that everybody in the body politic seems familiar with the tremendous impact that the other two branches can have on people, the executive and the legislature. And strangely to me, I am constantly reading that, that people don't really have a sense of how crucial the courts can be in their lives, what tremendous impact the courts can have over them. And that's really what you're describing here, right?
That's correct. And Larry, let me just say that we find that statistically, you find more pro se litigants than ever before in our system. I know that in probate.
Which means for the audience, no lawyer, somebody representing himself or herself.
And especially the indigent, where they cannot afford a lawyer. Lawyers are very expensive, as I'm pretty sure the gentleman around here can well attest to. And the fact is that they are now going into court, and they're representing self. And in representing yourself, you well know that basically the emotionalism, the emotional aspect of this case is very, 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 of course, it could be damaging to the person who's before the bench.
Right. Jan, when you have been in court, you have expected and not always found, I understand, as all lawyers expect and often don't find, that a case will be decided on the facts, really on facts that somebody is permitted to bring out and that the court will take account of it. Am I correct? You have found that's not always been the case, even though one expects it in the civics book model?
Well, I mean, I think that a lawyer, or at least I as a lawyer, certainly expect, and I know certainly my clients expect that the case will be decided on the law and the facts together, and that, you know, it will be an impartial decision. And what you find as a practicing lawyer, I mean, the experience I have had, and I know it's similar to every other lawyer that I know, is that the more and more experience you have with the court system, it becomes a mystery to you as to how a case is decided. You begin to feel, well, if it's not the law, if it's not the facts, you know, what else is going on here? I mean, oftentimes I had the experience, too many times, of being in court, something happens, and I said, well, it sounded like that was decided before I got here. In other words, there was another hearing before I got here that I wasn't privy to. And that is bothersome, I think, to all lawyers, you know, young and then becoming accomplished in the profession. And a cynicism builds up, I think, the older you get as a lawyer, that you must fight, that you have to fight every day. And I know it attacks at the soul of every lawyer as he goes through the practice.
And does anybody want to comment on the fact that we grant judges in most states and in the federal system life tenure, so that these expectations will be met because they will be independent? and so that they will resolve disputes fairly and on the facts. And so anybody want to make any comment, or is it just so self-evident?
I originally began my practice for one whole year in New York, where judges are elected. So I want to say flat out, the appointment process is better than the election process any day of the year. And I think that lifetime tenure, or at least now it's until a certain age, isn't it, is also important, because judges do have to, I think, have the security that their job isn't going to be dependent on, you know, one unpopular decision or one mistake. But all that having been said, why don't we have some kind of scrutiny periodically? Because people, as they stay on the bench, as they get more and more isolated in their lives because they're not permitted to have the normal kinds of contacts that we do, they just may forget that there's a real world out there and that their decisions impact that real world, and they should be subject to periodic review, peer review, public review, something that looks at their record and comments on it.
We'll get into every single one of these topics now. Let me say, Sydelle, that what you're suggesting is very similar to what is beginning to have a role in the academic world, which is post-tenure review. What you're suggesting and what somebody wrote about in the magazine was a form of post-tenure review. Now, let's see if we can establish some common ground in the interest of the fact that we are all lawyers, and none of us wants our license to practice law to be taken away. I take it that everybody, I'm a dean, I don't care if they take away my license.
Sometimes you hope that might happen to protect us from ourselves.
Or to force us into other careers.
Right.
Nobody here is saying, if I understand correctly some of the informal conversations I've had with you prior to this, nobody here is saying, or should be taken to be saying, that what we are going to talk about is true of all judges, is true of any judges all the time. Well, that's a little chancier. And nobody is saying that we should get rid of the judicial system as we know it. And nobody is saying that the judicial system for 200 years in American life has at every point failed to do good for the American polity. Nobody is saying any of that. But what we are saying, if I understand correctly, is that there are problems which we will address here. And just before we came on, Jan, you were talking about the fact, and I think perhaps we ought to discuss this briefly before we get into the substantive problems, because the ABA, the American Bar Association, is now de facto, as I understand it, attempting to put the quietus on criticism of the courts by creating new rules under which bar associations would be permitted, almost might even have an obligation, to rush to the defense of criticized judges. Right. You were pointing out that, like the executive branch and like the administrative branch too, and like the congressional branch, state legislative branch, the courts too should be subject to intelligent criticism and comment about what they're doing. Would you like to elaborate on that a little bit?
Well, maybe I could say it this way. I think that my life's experience to this point, I think, and being a practicing lawyer, I think has led me to have a greater respect and appreciation for open and honest discussion. And I find that when there isn't open and honest discussion, when there's secrecy, when there's darkness, that's when you start to have problems. It's always in the darkness and in the secret places that the rot sets in. And it's true of judges in being secluded and restricted, because there is access to them when they're so-called being restricted and limited access. It's just there are limited people who are having access, and that's not healthy. And I just think we always, as human animals, we are better for interaction with each other to smooth out the rough spots. And judges who have this incredible power over us need it probably more than anybody else.
You want to add something, Sydelle?
Yes, I wanted to make two points from discussions I've had the good fortune of having recently with federal judges that I've interviewed for another television program. And Judge Nancy Gertner is sitting on a case that will have importance in the field of arbitration and the securities industry.
Law, yes.
And she did what I think is unusual for a district judge to do. We see it much more at appellate level. She had a knotty issue, and she asked for a briefing by amicus. So that is friends of the court, which are people who are not parties to the dispute but feel they have something to say about the issue. And in doing that, she thereby is asking for public input, if you will, from different organizations who want to say something to her about the case. And I think that sort of thing could be encouraged.
Am I correct in thinking that Nancy Gertner, who is an extremely courageous woman, not to say brilliant, is in doing this trying to find out whether the fundamental factual bases which underlie a Supreme Court decision are in fact not true at all?
Well, I don't know what her reason for doing it is, except that she did want more facts. That's certainly one of the issues that she wanted. Simply commenting on the fact that it's a good idea to bring that kind of public reaction in. And then the second point is that Judge Sandra Lynch, who is on the First Circuit Court of Appeals and is the first woman to serve in that capacity in the history of of this jurisdiction, Judge Lynch said, you know, we are isolated up here. All the judges who were fairly new were surprised how isolated they felt. Their friends didn't want to talk to them anymore. They were afraid of improper contact. She said, if I write a decision that you disagree with, let me know. Write me your reasons. Don't keep me in the dark. Maybe there isn't anything I can or would do about that decision, but I want to know how you all are affected by the decisions I write. I found that a revolutionary statement.
Let me turn, if I may. I want to get back to all these points. They were sort of like table setting, as it were. I want to get to the main course now, and then the dessert will be what do we do about these things, which you folks have all been talking about. To what extent, Marty, I know that you've experienced this in the Illinois area, unfortunately, and it's also been experienced in Philadelphia recently. To what extent do you think that the courts are sometimes the perpetrators of plain dishonesty, bribery, on the take?
Well, if you want to start with just the level of bribery, of course, Chicago has a great deal of expertise in that field.
Champion.
Pardon?
The world's champion.
Right. Well, nobody seems to be trying to compete with us for the moment. It has been a serious problem in the court system in Illinois, particularly in Cook County. I think the problem really stems primarily from the fact that we have an elected judiciary in Illinois, and Illinois, of course, everything is very highly politicized, including the judiciary. And so the types of people who tend to ascend to the bench, or have in the past, have produced, not all, of course, because like in any area, most of our judges are fine, but compared to other areas, a high percentage of people who've been easily tempted and have been taking bribes. We had 18 judges, I think, convicted in the last scandal that the U.S. Attorney prosecuted. Then we had people thought that was going to put an end to this, and then a few years later we had a follow-up scandal where a number of judges were indicted and some resigned from the bench. And
you know, Marty, in 1981 I was involved in a case in the federal court, and the client, we were losing some early motions. The case ultimately involved lots and lots of plaintiffs and a $750 million judgment for steel companies and so on. But we were losing some early motions for a small client, and he asked me, he said, do you think this judge is on the take, federal judge? And I said to him, there is no way. This does not happen in the federal courts. This is heresy. Don't darken my door with such a suggestion again. In the next 10 years, 3 judges were convicted or indicted for taking bribes. 3 federal judges were convicted or indicted for taking bribes.
Well, it is unusual in terms of the number of judges. I think that a very small percentage are on the take. But look, one of the things we have to remember is that the judiciary is made up of human beings. So to some degree, people who get to the bench are going to reflect the population as a whole. And as much as we would like the process of judging to be based on the civics lessons we learned in school, that everything is honest and based on the facts and the law, a certain amount of human frailty is going to be there. Particularly with the judiciary, for the reasons that I think we've talked about here, of how important the courts are, we ought to be working hard to minimize that, even compared to the other branches of government, for 2 reasons. One, judges serve either for life or for a long time. It's much easier to get rid of a crooked legislator through an election than it is a crooked judge. and two, because they have so much power over our lives. So what we ought to do, and I guess we're getting ahead to the dessert a little bit, is work on a system that out of the whole population of human beings who have these frailties, we tend to select people who are less likely to have them. In an elected system like in Illinois, where judges come up through being precinct captains. Really, it used to be. It's better now. One of the famous statements, and this should clarify for everybody, that came out during one of the judicial slate makings in Cook County, where the Democratic machine really controls the bench. A few years ago, the party had decided to allow these slate making sessions to be open so we could hear what was going on. And one alderman, who's also a very powerful politician, got up and said, I am for so-and-so to be slated as part of our slate. This person will be terrific. He will be an alderman's judge. And he got slated and was elected. And that was the most important thing that could be said about him. Yeah. So, when that's the selection process, you're going to have a higher percentage in other places of people who are going to be found being corrupt.
So would we basically agree that it's not a widespread problem? It happens, and when it happens, it casts terrible dubiousness in people's minds on the judiciary.
We ought to if I could just, I hate to dominate, but there is a story that just happened in Chicago that I think is so unique. It should be fascinating to all of us who practice law. There was a mob hitman who hit somebody, killed him with a shotgun, back about 20 years now, and went to trial, chose a bench trial, which he had the option to do, and the judge was paid off. I think the bribe was $10,000, and in the face of an eyewitness who got on the stand and said, that's the guy, the judge said, acquitted. So the hitman was freed. The judge was subsequently investigated by the U.S. attorney, and before he could be indicted, committed suicide. Years later, we had a new local prosecutor elected who decided to re-indict the hitman. And the hitman defended it, went all the way to the U.S. Supreme Court, arguing this is double jeopardy. I was already acquitted. And the Supreme Court said, this is so fundamental to our system, there could not be double jeopardy because you were never in jeopardy the first time because your judge was bought. Right. And they allowed it to go back, and the case was just retried a few months ago, and of course now the same eyewitness fortunately was alive and he was convicted. Right. But that's unusual. Usually when you're the victim of a bribed judge, you're stuck. Your case is over. Yeah.
But I think that I think it would be what we don't want to do is if you focus on those that are clear, the clear cases of judges who are really they're criminals, and they're criminals like any other kind of criminal. They don't belong on the bench. I think it's too easy. It's an excuse for not really dealing with, I think, a more fundamental problem of really people who are not criminals, who are good people, but end up being bad judges, and that to me is the serious problem for the profession. Because I think if we only had to deal with those who took bribes, I don't think there's a lawyer that have any problem with that, because again, the incidence is so small that really does not interfere, I think, with the basic practice.
We're very fortunate here in Massachusetts because of the fact that one of the things about the judiciary is that you take a look at the history, is that there is honesty attached to it. Yeah. And we don't, we're not like Chicago in the sense of, at least we haven't seen any cases like that coming out of Chicago.
You did have a mayor who was elected from jail, though.
That's true. That's true.
That's right. But he wasn't a judge. Okay, but he wasn't on the judiciary.
And he wasn't the judge's mayor. So.
He wasn't the judge's mayor. But I think that if we take a look at and I agree with you as far as the percentage is so small, so isolated. And clearly, I mean, we have judges that are bad judges, we have judges that are good judges. We have lawyers that are bad lawyers, we have lawyers that are good lawyers. Okay, I mean, we have the bad and the good no matter where we are. And that's why we have very stringent procedures to deal with individuals who must, of course, have total honesty in what they do and what they dispense.
Jan, let me bring in something here, ask you a question about something. You know, in saying that one is really focusing on a very small part of the problem when one focuses on people who are literally criminally on the take. What do you think about the fact that, as is true in Congress, as was previously true in the executive, as is true in a lot of life, it's not always not always a question of being literally on the take in a given case.
Right.
It can be a question of free trips to make addresses to groups,
Right.
being placed on committees that are prestigious. The ABA has federal judge after federal judge on its various committees. These kinds of things where people benefit. There can be fine people. Some are wonderful people. But
Yeah.
what do you think?
Well, I mean, I think that this is the kind of the sociological aspects of judging, which is that one has to understand what is the culture in which they're living, and you know, they're clerks who they befriend and who are important. You know, they're important mentors to.
Let me explain to the audience, if I may. A judicial clerk is a young man or young woman just out of law school, either immediately out or out only a year or two, who spends a year doing research for and helping the judge write opinions, and with whom the judge discusses all manner of legal problems. So this is not somebody who's just filling in numbers. This is an important
a very close relationship and a very important relationship for the development of certainly of the clerk's development as well. But then that clerk then goes someplace, and usually where they go is to powerful and connected law firms, and so it's a very closed arena, I think, which has sociologic complications, I think, or consequences that we have to recognize. That the judges are also, as these people grow and develop, again, there's the committees and the conferences that they all go to. It's the world that they all inhabit, and they develop relationships. So you don't have to, you don't have to have a corruption of the judicial mind because somebody owns you by money. But there are relationships that form that, unless we are very open about it and very conscious of it, in very subtle and not so subtle ways, control how you look at cases and how you dispense justice, which I think, and again, I use the word corruption because I want to connote that it does despoil the dispensing of the justice. The justice is not well-formed and not well-funded, but it's something else which is very idiosyncratic, in fact, is quite capricious, which I think is the thing that drives every practicing lawyer crazy, is the capriciousness with which too often, and it's more the rule than the exception, you feel that the judge, man, woman, is looking upon the case and deciding issues.
Can I ask this, Jan? Could we sum up much of what you said, not all, but much of what you said by saying that judges either come from or join a particular socioeconomic class with particular socioeconomic views and don't get a lot of exposure to other people who have different views, and so would you agree with that, David?
Not quite.
Okay, what do you think?
Because I think that you have certain judges who are community judges. They're out there in the community, they're doing things in the community, they're getting a feel. You take juvenile judges, for instance. We have a very able juvenile judge in Boston, and he is a community person. He grew up in the community. His background, he had a real feel for these young kids that are coming before him. So, I mean, I think that he's a hands-on judge. And there's nothing wrong in being a hands-on judge. There's nothing wrong to going out and trying to see exactly what the field is out there, because you're going to make these decisions, and these decisions are going to have a tremendous impact on lives before you. So you should be that hands-on person.
Well, I would look at that as a very healthy thing, but I would suggest that, knowing from my experience, that it sounds like an exception rather than the rule. And that sounds to me like someone who is bringing a life experience and staying connected to the world, which is improving the level of justice.
Well, there's a balance, isn't there, that judges have to walk, and we in selecting judges have to look at. We want diversity on the bench so that we have people from different backgrounds, so that we don't have as much of this club atmosphere as I think we all agree we used to a decade ago. And we're breaking through that now a little bit, not as much as it should, but a little bit. At the same time, one of the hardest things I think a judge has to do is to look at each case just on its facts and on its law, because after all, who's presenting that? Mostly, before trial, it's the lawyers. It's the motion hearing. The lawyers speak to the judge, and their credibility is at issue. And so the judge who feels like they know this particular lawyer, because they've been together on this ABA committee or whatever, probably can't help, that human nature that you talked about, can't help but credit this person, whereas this outsider, this brash young man, you know, representing this group on a new and novel issue, doesn't bring that kind of credibility.
Or brash young woman.
Or brash young woman, thank you.
Yeah.
Yes.
What we're talking about.
Don't mean you.
I was thinking of Jan, not myself.
What we're talking about is not unique to the judiciary. Let's face it. Up until recently, within the last 10 years, particularly if we take a look at the federal judiciary, like the other branches of government, like the corporate world, this was a society dominated by white males from wealth. And that's who most judges were, and to a large degree still are. Now, we're finally making some progress. More women are getting on the bench. More minorities are getting on the bench. So these white males are going to come to the bench with their own worldview. You can't separate that from being a human being. The better ones, I think, are the ones who learn to exercise self-restraint and to try to work. And it's difficult, I think. All of us have been in positions where we've had to step outside our own roles and to try to put aside our own prejudices. The ones who fail are the ones who don't seem to care and say, I'm just going to let my prejudices dominate the day. The better ones are the ones who put them aside, and I don't think anyone can do it perfectly. But I do think that
Or make an attempt.
Or make an attempt.
Yeah.
And I think what still happens is that although we're getting more diversity in terms of race and sex, I don't think we're getting more diversity in terms of class. Mm-hmm. I think the people who tend to get on the bench are still from the wealthy, from the power centers. The powerless, by definition, tend not to get on the bench. Right. And that is a big problem within our system, I think.
Let me ask the question. And then I'm going to come back to a whole litany of things that relate directly to what you just said, Marty. I hear a lot, and if this weren't a society in which it is now being said to be a bad thing to have a victim's mentality, I would say I've been victimized a lot. But certainly I've been on the receiving end. I guess that's fair to say.
You mean you've lost some cases? We've all done that.
Oh, I've lost cases, and not mine didn't. I've lost cases, and mine didn't. I think
exactly.
that's where everybody fits in here.
Right.
I hear a lot from practicing lawyers about two things: arrogance and treating people terribly. I even hear that from corporate lawyers and major law firms.
Yeah.
Would you like to comment? I take it these are sort of two sides of the same coin. But why don't you start off by commenting on that?
As soon as you're talking there, I'm very passionate about this issue because I think to me, this is the overriding symbol, I think, of what we're talking about, is that when you go into the courtroom, and again, more the rule than the exception, at least from my experience, and granted I don't get in front of lots of judges, and I try and stay away from a lot of judges because of it, is you feel a lack of respect for not just your case, but for you as an individual, that they do not, and therefore everyone is, your clients, your witnesses, this is just this lack of respect, and you don't know where it comes from. I mean, do they know me, or did they know, where, it's that something happened before you showed up that gives them this slant on the world that makes you feel not respected. And I think that's the worst part of lawyering when you go before a judge, this feeling of not being respected, because it means so much of how you are treated in the courtroom and then how you respond to the treatment and try to understand what is happening, in this case. And I think for lots of lawyers, the courtroom becomes a very dark and dangerous place because of this feeling of lack of respect. And whenever we see judges mistreating witnesses or other people, this kind of arrogance and this, they're in charge, a very corrupting thing, this power, and then is very demeaning, and I think engenders a real cynicism on the lawyer about what is going on in the courtroom.
What is it? Go ahead.
I mean, you mentioned something way back at the beginning that I think each and every one of us has experienced. Haven't we all had to reassure clients who really could see themselves or us being mistreated in court, and we had to take them back and say, no, the judge is a fair person and just happens to be, overworked at this particular moment or something, and you find yourself apologizing, right? Trying to uphold the legal system so that your client won't become, won't lose faith.
Right. If the judge is demeaning to you, the attorney, the advocate, imagine how demeaning that judge is going to be to the client or to the person who is pro se.
Pro se, right.
Okay. You know, one of the things.
Well, we all see that. When we see pro se, it's extremely upsetting to sit as a lawyer and watch a judge treat a pro se client.
Well, you know, I was going to say that one of the things that I do is that when I'm in court and I'm representing my client, my client is sitting there, and the person is pro se. I am so in tune to what's going on. I want to see exactly how that judge is going to respond to that pro se litigant. That person is there in that court, no attorney, but I tend to find that, especially in probate, that judges, they tend to be very sensitive. They're very compassionate. They're very understanding. And I don't know it's because of the fact that it's all open and everyone's listening, it's recorded. I think that basically is that we have a new breed starting to come to the judiciary now. And the selection of these individuals do you have what is called judicial temperament?
Yes, we talk about it now. Right. We talk about judicial temperament as a qualification for the job.
Precisely, and that's a big qualification.
But you know, lawyers hate working in cases where there's a pro se on the other side. It's difficult because they don't know the procedures. You can feel like you're taking advantage of them, and yet you have to represent your own client zealously. Pro se is difficult. That comes from the expense of lawyers, and that's a whole other
Right. Well, I will tell you this. The Chicago Council of Lawyers came into existence 28 years ago for the purpose of trying to upgrade the quality of the judiciary in Cook County. And we do a lot of things now, but one of the things we focus on is evaluating judicial candidates. We also evaluate sitting judges. And the most difficult task, we try to do a good job, is to evaluate a person for temperament when they haven't been on the bench.
Right.
Now, that is just a very difficult human trait to predict. And I don't think that rich white men from powerful law firms have a monopoly on arrogance and discourtesy. We see it from all kinds of people who get on the bench. Some people have never been in positions of authority before, and they don't quite know how to respond when they put the robe on. All of a sudden, they get very impressed with themselves. It is a...
I call that robe power.
Well, we call it some other things too when we're not on the record. But it's a very difficult task, but at least if an effort is made to sort out people and to talk to, for example, when we evaluate judges, judicial candidates, we will generally try to interview 20 people who have known this person, been on the opposite side. It's a very time-consuming task, and to try to sift and winnow and get a sense, and our job, we don't do it perfectly either, but to try to ferret out people who have not shown an ability to be balanced, to be restrained, because I think, and Jan alluded to it, I think if you had to single out the biggest problem facing the judiciary today, in a way, I don't think it's bribery. I think that's a very tiny percentage.
Sure.
I don't even think it's ideology, although certainly the judiciary is far too conservative for my taste. But I think it's an arrogance combined with an ideology.
That's true.
And so that people get appointed who just think they can run roughshod over the facts, the law, the people before them, because they want to do it the way they want to do it.
Why do people like this, Marty, and I know Chicago Council has had some very explicit things to say about people who are very brilliant. Chicago Council says they're very brilliant, and none of us would disagree. Why do people like this, or how does it come about that people with this kind of arrogance get on the federal or state bench?
Well, in the case of the judges on the 7th Circuit Court of Appeals, which is our federal appellate court in the Midwest, I can speak a little more knowledgeably, although I think it's true of others around the country. We have 2 judges who were professors at the University of Chicago, actually still teach there, Judge Richard Posner and Judge Frank Easterbrook.
We're brilliant men.
There's no question they're brilliant. They're regarded as 2 of the best federal judges. But they both have suffered from this problem of arrogance, the problem of mistreating. These are appellate judges, so the clients are not in front of them, but the lawyers, I've been there, and particularly Judge Easterbrook has a reputation of being very demeaning towards the lawyers who are practicing in that court. I think one of the main reasons is, and it's something that I look at when I'm considering who I want to support on the bench, is that these are people who've never really practiced law. They've spent their entire lives in academia or maybe in the Solicitor General's office in Washington. And I know everybody here has practiced law and represented clients, and until you have had the real-life experience of a human being walking into your office with a problem, with not very much money to solve the problem, and you try to say, what can the legal system do for you that you can afford to get from here to there, to either be compensated for an injury or to deal with a custody battle or to sue the guy who left a hole in your roof or whatever. Until you've been through that many times for many years, I don't think you have a good sense of perspective on what the judicial system is supposed to be about. And so what I find is with the academics, not all, of course, there have been some brilliant academics that went on the bench, Justice Frankfurter, I suppose, we would all think, and so forth. But many of them, you know, it reminds me of one of my favorite lines about a comment on the political system that I remember reading in David Halberstam's book, The Best and the Brightest. And he retells a story, allegedly, that when the Kennedy administration was first sworn in to office, and Lyndon Johnson, the new vice president, was down meeting with his old mentor, Sam Rayburn, and he was telling him of the brilliant people that Kennedy was putting in the cabinet, McNamara, and people of this nature. And Rayburn reportedly turned around and said, well, I would be more impressed if one of them had once run for sheriff. And that is, you know, you need some real world growing up, I think, to have some...
Well, something else about the former professors on the bench, and we have a couple of those in Massachusetts, both on the district court and on in the appellate capacities, is I think they have spent a number of years teaching and being encouraged to develop a scholarly point of view, a point of view that purposely is not bogged down by such things as real facts. And so they think theoretically, they teach theoretically, they write theoretically, and they've been promoted academically for doing that. Now, being appointed to the bench, here's the chance to impose upon the great unwashed these lofty principles that, you know, they've been teaching at Harvard for all these years. And sometimes we can suffer from you know, I've had the experience of reading decisions of a judge going off on principles that were never advanced and theories that were never advanced by any party to the case because he thought, you know, those should apply.
I want to introduce one other element to this. Is I think we all should also recognize as lawyers that there is also a corruption of the system itself which has an impact on judging. I'll explain it with this example. I have found that judges who had a very difficult reputation as judges on the bench, who have retired and then gone into mediation, and I've had this personal experience, I know many others have, they have actually flowered in the process as mediators and problem solvers that you never saw them exhibit while they were on the bench. And so it begins to make one think that perhaps there is also a systemic problem at play here, that the adversarial system and the way we have constructed and the way we practice it also has an impact on human beings like judges who have to sit in judgment and are forced to make these either-or decisions, as opposed to, and there's a big, I think the practice is being revolutionized because of all of the things we're talking about. Lawyers now are understanding trying to get their clients to resolve their disputes outside the courtroom because of the mystery involved there, to allow the clients to have a more control over the problem-solving process. And it's revolutionizing, truly revolutionizing the practice. It is now becoming a place for retired judges to go to, like I say, to flower now as problem solvers. I think we have to think in terms of the systemic issues that cause that distinction.
Know, if I may, go right ahead.
I agree with Marty. One of the things is that basically is that we have to really have due diligence, and due diligence before the elevation process is going to take place. They do a very thorough search into the background of the individuals who will be, of course, who would don that robe and who will make decisions and have an impact on people's lives. And that's up to the different commissioners and different bodies to do. And I'm talking about due diligence is that not just to go to individuals that an applicant would put down who would, of course, embrace that person, but to go to someone who is on the other side, who tend to really know that person, who's been very active with that person, and know exactly what that judicial temperament. You know, judicial temperament is something that you can shield. You can hide it. But well, once you put that robe on and you undergo this metamorphosis, it's out there. And there's nothing that you can do. And that is what each of us as lawyers have been faced with, is that we have had judges who would scream and who would yell from the bench. And you know, if they're going to treat us that way, as far as lawyers, then under the circumstances, they would treat anyone that way.
Let me say this, David. And those are not necessarily, and in most cases are indeed not, numerically, ex-professors.
That's right. Yeah, precisely.
Is there something systemic that's going on here that seems to affect many people who take the bench? And I agree with you. We're trying to change around what we do in our law school to be doing things that no other law school is doing, precisely because we think that systemic problem exists.
Right. I think it's, again, I believe that there is this, the court system as we have presently practiced in it is a very 19th century model. And I think we're beginning to recognize that because of all the problems that we're talking about that affect, judging, which is obviously at the power center of the system, we want to kind of exert more communal control over the decision-making process. It is this giving to judicial discretion, which I think practicing lawyers find is a very corrupting thing. That we are empowering human beings, as wonderful as and as good as they may be. I believe it is fundamentally perhaps a corrupting process to put so much on an individual to make these decisions and to expect them to always be wise and fair-minded and to know what's going on, even when they want to be. And of course, the real problem also is many don't even want to be, but and you try and sift those out. And I think that there's this more of a need to this kind of open, honest discussion, and to get outside the courtroom in order to have that open and honest discussion. And like I say, when they come down off the bench and you put them in a room and they're the mediator, they speak with wisdom and they speak from a life experience, I think, and they become very adept at problem solving. Again, you don't see expressed in the courtroom, and that's got to be systemic, not human.
We're supposedly have a jury system of trials, and supposedly our legal system isn't dependent always on the wisdom of one person on the bench. And one of the points I'd love to hear discussed is whether we believe that jury verdicts really count in our practices anymore. I have had a number of jury verdicts, and now we see a number of them publicized, where they've been tossed aside.
Or nullified by the judge.
So many times. In the personal injury area, which is not an area I practice in, but you have these multi-million-dollar awards. They make the headlines, but in point of fact, the plaintiff doesn't see much money, sometimes doesn't see any money, because the judge takes away part of the verdict or orders a new trial, and this kind of balance against the judge that's called the jury is then overbalanced or nullified by the judge.
Let me ask this question then, Sydelle. Let me put in the context in which you have raised it, one of the most bothersome issues in my mind in the court system today. The Chicago Council of Lawyers have written about this issue extensively, and I was shocked that a bar association would dare to say, no matter how true it is, would dare to say what the Chicago Council said. Isn't it true, I'll put this as a question and you folks all comment on it, is it or isn't it true that one of the reasons that first cases are not getting to the jury in the first place, and secondly, decisions made by juries are being overturned, is that judges have taken it upon themselves to perform a function which is supposed to be for the jury, the function of deciding what the facts are in a case, point one, and relatedly, point two, what is your opinion of the following statement? When they want a particular result, they either ignore facts or they make up facts. Now, I throw that open for anybody's discussion.
Well, this is just imposition of the will. I mean, I think that this is, there's a real problem in the judiciary. You did touch on it earlier and said ideological. I do believe that there is a real illogical problem on the bench. I believe that a lot of judges are now being encouraged, really, to be ideological. What I mean by that is that they are, say, in my practice, I do a lot of environmental cases, toxic tort cases, cases which are really on the cutting edge of science. Do chemicals cause cancer and that kind of thing. And what judges are doing all too often is they're taking off the black robe and putting on the white lab coat, and they're saying, well, I'm not going to allow this scientist to speak because I've decided that that science isn't valid, or I've decided that his or her conclusions aren't valid, and so therefore I'm not going to let them come in and tell the jury about this. I won't let that be a jury decision. And that's happening to a great extent. It's now been up in front of the Supreme Court. Now it's now going on the second time. What are the rules that prevent the judge, you know, are the circumstances in which they can take off the black robe and then put on the scientist's lab coat and start saying what the science and the medicine is?
Larry, I believe that we have really undergone a real metamorphosis in our society, and you go back into the 60s and 70s. I'm probably giving my age too. But one of the things...
You're in your 60s, 70s?
But I was very active in the 60s and 70s. But one of the things, of course, is that now we have television in the courts. And the televisions, of course, and TV and the news media, they put a tremendous amount of pressure on these judges. Okay. And the pressure, of course, is that it's not what the jury's going to say. And we know we just finished a case here in the Commonwealth of Massachusetts. But basically is that what is the crowd outside doing? I mean, judges are like anyone else. They're human. They go home, they turn on TV, and they look and they see exactly what's going on. And you know, and you can rest assured it does have some type of effect on them, how they're going to do something. And they say, no, we don't. But truly, they do. Okay.
And that's causing them to determine facts one way or the other?
Well, I think it's persuasive. I think it's very, very persuasive.
But I want to counter. I want to counter that because
Okay,
I find that it's the lack of the openness in the courtroom.
Right.
You know, the darkness that was in the courtroom, which is the corrupting aspect. I feel more comfortable having more openness, more involvement of the public into what is happening in that courtroom. I like the fact that judges are thinking about the wider audience. And the example I'll just give you is my own personal one from the Woburn case, is I suffered, and my client suffered, I think, a real abuse of power, decisions that were quite abusive of fundamental rights. And it was done in broad daylight in the sense that it was done with every lawyer in Massachusetts understanding what was going on. This had to do with withholding of evidence and things, and the judge not recognizing it. But what I found when the book came out, which has now become a national bestseller, and everybody is reading it, lawyers, lawyers' spouses, lawyers' friends, lawyers' neighbors, people who are not lawyers who then get to talk to lawyers and judges, that is when finally we confront the abuse. That, in other words, as a profession, we couldn't confront the abuse, even though it was done in broad daylight. We all knew about it. It was on the front page of the Lawyers Weekly. But when it became a book and we all talked about it in the general, became kind of the general culture, all of a sudden there was a greater wisdom about, well, that's not right. You know, gee, that was a fundamental right here, and you know, withholding evidence is a bad thing. But we didn't talk about that before. It was just our profession. So I found the power of the book, and now I think also the discussion of the movie. But so I like the openness. I like the connection. I like the general public knowing what we do and how we do it. It's good for us, I think.
But isn't
We
that
need
awesome?
it in the federal courts,
But-
too.
yes.
I mean, the federal courts are a big mystery, and you mentioned at the beginning, the judiciary is the third branch of government. It's equal to the administration and the presidents and the cabinet, and it's equal to the legislature, and it's the most mysterious branch of the government.
But
and if we shone some light on it, we'd be better off.
But you know, one of the things that I enjoy immensely is that coming home late at night and turning on the on cable, and what do I see but the different talk shows. And they're not talk shows, they're talk shows about law. I mean, now we're in the courts. I mean, the media's there, they're in there, they're listening to everything. It's open, and you know, we said the light of day coming into the courtroom.
Right.
The light of day now is starting to come into the courtroom, and we're starting to see exactly what judges are doing. And, of course, the mystery is now being removed.
But not in
Well,
the federal courts.
I think there has to be some balance. I'm just thinking, if you think about the Simpson trial,
Must be.
which we, well, there is one good part that I remember that we've all sort of forgotten because the trial was so awful. But the preliminary hearing, a few months before the trial, was one of the great educations about the Fourth Amendment to the public. We've all forgotten about it.
Yes.
But the public watched those hearings about the suppression of evidence very carefully. And I found that when you know, frequently we get into arguments about people being excused for technicalities and what does all this stuff mean as though it's not important. All of a sudden, the average citizen got a chance to hear about what the Fourth Amendment was about. And say, oh, that's right, I don't want the police barging into my house. It was very educational. Had the judge, I think, controlled the courtroom during the trial might have been educational too,
Yes.
but of course it deteriorated. We need to go into it. I think that What my observation, Larry, about the question you asked about the judges deciding what the facts are, or deciding what they aren't, is more of a problem at the appellate level than at the trial level, generally speaking. My experience is that trial judges, by and large, have been better, have been closer to the situation, been more open to being persuaded to what the facts are, or should be. Certainly we do have some judges saying, well, I'm just not going to hear that expert. I think, by the way, we've moved in the wrong direction on experts. I'm a believer in the adversary process. If your expert is touting junk science, and then it's your opponent's job to bring that out. But at the appellate level, and we certainly have this in the Seventh Circuit, you have judges, Sydelle mentioned, who, and I think you stated it exactly right, their whole training has been to have an ideological or a theoretical point of view. Sometimes it's not a right or a left ideology, it's just a theory. Just their own theory. Right. And a case gets tried, a record is made, there's testimony there, the jury says, I believe X and I don't believe Y. Right. That's golden in our system. Those are the facts. And the appellate judge writes an opinion, and of course, unfortunately, you don't know how bad it is unless you were the trial lawyer, and you read the opinion and say, that wasn't the case I tried. The person just said, I'm going to reach this outcome to foment this theory, and in Chicago, of course, it's the economics and law theory, which has some good points. But, and then they said, these are the facts. Or these are what, I read an opinion by Judge Poster recently in a securities fraud case, and he actually said in his opinion that he was upholding a summary judgment, and he said, I'm going to uphold this because the facts may be such and such, and therefore I'm not going to let this case go to trial because I believe it may be this.
Let me ask this. I wanted to get back to that, because that whole legal technique of saying what the facts may be is well, I think we should just get rid of it. It's of course silly, but
well, we already are rid of it in theory. That violates all the rules of judging and lawyering that we know about. But when the judge has the final say, that's...
Let me say for the benefit of the audience, Marty, that when you said he upheld a summary judgment, what that in effect means for the audience is that he upheld a lower court ruling saying, I won't even let this go to the jury because I'm going to say what the facts are or are not. Right. Jan, Marty made a comment which I'm not that experienced at the trial level. In my limited experience, I have run across a situation where the trial judge, contrary to what may normally be the case, as Marty said, just didn't care what the facts were. Mm-hmm. Have you had such an experience?
Well, I think I definitely have had such an experience.
I thought you might say that.
Yes, right. Definitely written about in Jonathan Har's book, a civil action, which, I'm proud to say, pleased to say, is in many law schools in the country as a point of discussion. It goes back to my point about how we need
Can I tell you something about that?
Yes.
I could only read it 20 pages at a time. It is so painful.
Right.
That I couldn't read more than 20 pages at a time. But go ahead.
No, I think that he really got into the belly of the beast. He really talked about what it means to do lawyering in our system, all of it, the good, the bad, and the ugly. And so I think that it is this, need for this open and honest discussion because, yes, there is this arrogance of power, and it's a terrible feeling to be a lawyer, to go into court and to have done your job, to marshal together the facts, to have the research and to say, look, here's how the facts fit with the legal theory. We don't all have to have pride of ownership. We can be wrong. But the point is to have done your job and then to have the judge come and say, well, it's not important. In other words, it doesn't really make any difference that you did your job. And so therefore you say to yourself, well, who am I? If I'm not a lawyer, am I an influence peddler? I mean, what is left to me? What is my function here for my client?
I have to, I've been told that I must cut off the discussion. And I want to thank lady and gentlemen for being here. Now let me say this. For the first time in any of my experiences moderating these shows, I have made no effort, none at all, to get through the outline of the topics that I wanted to have discussed. And you touched on so many things that are so important and that we did not get to. And one of the reasons that I didn't make an effort to get through it is I would like us to come back. And I will try and arrange a date that's convenient for all of you. And Marty, you live in Chicago, so your schedule will be very important if you're willing to come back. And we will continue on with this. I think this is such a crucial set of topics that we are discussing. We will continue on with it. For the audience, thank you very much for watching and listening. We hope that it was informational and educational, and we hope that the next program on this subject will be equally so. Thank you very much.